Those were like substantial search of foreign exchange reserves. Those were growth in foreign trade and rationalization of tariffs, and also a current account convertibility, and also liberalization of Indian investments abroad, and also introduction of automatic route for investment, and a last one, foreign equity participation, etc. So eventually, the Foreign Exchange Management Act, FEMA. This bill was introduced in 1998, but lapsed as Parliament was dissolved before its passes the FEMA. And next, this bill in 1998 was referred to the Standing Committee on Finance, where after FEMA 1999 got passed by the Parliament. Let us move on to what is Foreign Exchange Management Act, FEMA 1999, because which is passed in 1999, which is passed in Parliament during 1999, so called, so that we call it as a FEMA Act 1999. If we see this pyramid, we can understand what are the classification of FEMA, and also specified for FEMA, and also how it applies in Indian citizens, and central government has authority given by what authority has given by central authority to FEMA. So with this chart, we can understand. And the Foreign Exchange Management Act, FEMA Act 1999, was enacted and reinstated and amended the law relating to foreign exchange with the objective of facilitating external trade and payments, and also for promoting the orderly development and maintenance of foreign exchange markets in India. So let us move on to a few things on FEMA. A free transaction on current account subject to reasonable restrictions that may be imposed, and also RBI controls over capital account transactions and control over realization of export proceeds, and also dealings in foreign exchange through authorized person like authorized dealers, money changers, or offshore banking units. These were authorized people. And also let us move on to RBI regulations. What are the RBI regulations? Here I am sharing the picture of RBI regulations if we see. So these are the RBI regulations. What exactly are we? Reserve Bank of India. So it is a central bank responsible for managing the country's financial system. So in earlier also I discussed about RBI, what is RBI and when it established and what are the functions, kind of things I explained in earlier earlier classes. So RBI is a central bank responsible for managing the country's financial system. And also the first governor of RBI is Sir Oborne Smith. And the first Indian governor of RBI is C.D. Deshmukh. These two people were very important to perform an exam, and the RBI concept was inspired by Dr. B.R. Ambedkar and B.R. Ambedkar's strategies in his book, The Problem of the Rupee, its origin and its solution. In that, he mentioned the concepts of what exactly a RBI and their concepts. And so RBI established in 1946, and Hilton Young Commission, he recommended that commission has recommended the establishment of RBI. And also in 1934, Reserve Bank of India Act passed by the British government in 1934 before independence, and 1935 Reserve Bank of India formally established on April 1st in Calcutta before independence. And 1949, after independence, RBI nationalized previously owned by private stakeholders. So if we see a few functions of RBI, supervisory functions and monetary functions, issue of currency notes, manager of foreign exchange, banker to other banks, and banker to the government. These are the few functions which I mentioned on a slide. First one, supervisory function. So authority to use issue bank license, open branches, set minimum reserves, and also inspect commercial banks. These are supervisory functions. And coming to monetary function, the RBI aims to maintain the price stability while promoting economic growth. And also currency notes, issuer of currency note, exchange and destroys currency notes while circulating government minted coins. And also manager of foreign exchange, uh, custodian and regulation, and also currency stability. So here, Reserve Bank of India intends to stabilize INR or US dollars currency volatility. So coming to banker to the other banks, custodian of the cash, Reserve Bank of commercial banks, and also lender of last report. So here I mentioned few other functions. And let us move on to Competition Act 2002. What is a Competition Act 2002, which is a 11th unit under Block 3. Since attaining independence in 1947, India, for the better part of half a country, thereafter adopted and followed policies comprising what are known as command and control laws. Command and control laws, and also rules, regulations, executive orders. In 1947, India, for the better part of half a century, thereafter adopted a followed policies like a command and control. So the competition law of India, namely the monopolies and also restrictive trade practices act 1969. So that is nothing but MRTP Act was one such. So MRTP, monopolies and restrictive trade practices 1969. What exactly this act? Let us see few objectives of this MRTP Act. So prevention of concentration on economic power to the common determinants, and also it controls of monopolies. And one more major objective is to prohibition of monopolistic trade practices. And the last objective of MRTP is prohibition of restrictive trade practices and the prohibition of unfair trade practices. These are few objectives of MRTP 1969 Act. So regulations of trade practices. What are the regulations of trade practices? So let me give you a first trade practice is monopolistic trade practice. What is a monopolistic trade practice? So it is a concept of power which manifests itself in one's power. So to control production, supply, and also to control price, to prevent, reduce, or eliminate competition, to limit technical development, to restricted capital investment, and also to impair the quality of goods. This is a concept of monopoly and regulation of monopolistic trade practice. One more practice is regulation. The first practice, monopolistic trade practice. Second one, regulation of monopolistic trade practice. So the act, this monopoly regulation of monopolistic trade act prohibits monopolistic trade practices of companies covered by it if they are found to be prejudicial to the public interest. So, under Section 2, subsection H of the Act defines monopolistic trade practice as a trade practice which has are likely to have the effect of maintaining practices at an unreasonable level by limiting, reducing, or otherwise controlling the production or supply or distribution of goods of any description, or the supply of any services or any other manner. And next, restrictive trade practices, this which is a third practice. A restrictive trade practice, RTP, is generally one which has the effect of preventing, distorting, or restricting competition. So, in particular, a practice which tends to obstruct the flow of capital or resources into the stream of production is a RTP, restrictive trade practice. So it has a every trade practice which has in restraint of trade is not necessarily a restrictive trade practice. Next, let us move on to unfair trade practices. What are the unfair trade practices? Essentially, unfair trade practices falling under a few these below categories which are introduced in 1980. Let me review the unfair trade practices which are introduced in 1948. First one, misleading advertisement and false representation. Might be any product or any good, misleading advertisement and false representation, and bargain sale, switch selling, and also offering of gifts or prizes with the intention of not providing them and conducting promotional contests. And next, product safety standards. And one more unfair trade practice is hoarding or destruction of goods. And one more trade practice is making false or misleading representation of facts, disappearing the goods, services, or trade of another person is also a prohibited trade practice under the Indian law. But still, in India, there were many trading practices were there. Like if we take any cold drink or any soap or any beauty cream, these were our unfair trade practices. And next, coming to Competition Act 2002, what is a Competition Act 2002? So let us discuss a few objectives to ensure fair trade practices by prohibiting trade practice. So let me share the screen. So few objectives here I mentioned. Competition Act 2002 objectives here to ensure fair trade practices by prohibiting trade practices, to promote sustainable competition, to promote consumer interest, to ensure freedom for the trade, to equality in trade. Here, uh, to ensure fair trade practices by prohibiting trade practices. If we observe in a television channel, there were a number of untrade practices which we are observing on smart boards or smart screens, which were unfair practices. So, with this Competition Act 2002, we are ensure we need to ensure that fair trade practices has to be held in advertising such products, and also to promote sustainable competition. So next object is to sustainable competition. Definitely, if trade practices are good, definitely the product will be have sustainable competition in a market. And next one, to promote consumer interest. So consumer need to consumer is nothing but a customer need to show their interest to buy the product if it is a genuine product. So such interest a consumer need to show on promoting the goods or services. And next, to ensure freedom for the trade. to ensure freedom for the trade. So this is the fourth objective. Definitely all businesses, any product, all products need to have freedom for their trading, like a registration and freedom to get a selling. These are the things which we need to have. And next, to create equality in trade. Every product need to get their own registrations and also their own equality in trading. Like from government, they need to get such kind of privileges to find. And next, move on to Competition Commission. What is a Competition Commission of India? So administration and enforcement of the competition law requires an administrative setup, and this administrative setup should be more proactive than reactive for the administration of the competition policy. So, Competition Commission of India in the Act has been entrusted with the following two basic functions. Those basic functions are like administration and enforcement of competition law and competition policy to foster economic efficiency and also consumer welfare. And next, if we see one more basic function is involvement proactively in governmental policy formulation to ensure that markets remain fair, free, open, flexible, and adaptable. And next, let us move on. There are few provisions of the Competition Act 2002. What are the provisions? Let's see. First provision will be, as usual, safeguarding wellness provided by the Act. Definitely, it should have the safeguarding wellness provided by the Act. What has been prohibited, and this law prohibits the deliberate exploitation of a dominant market position by firms, and also it prohibits the limitation process, limiting access. So, which includes the agreement to limited production or supply, and also agreement to allocate market, agreement to fix price, and also big rigging or concealed billing, and also exclusive supply, and also refusal price maintenance. These are few provisions which has which is having in a Competition Act 2000. And next, legislative development. One more provision of the Competition Act 2002 was legislative development. What is a legislative development? Now, paying attention to the legislative part, originally the government enacted the MRTP Act 1969 to deal with the competition, and it came into force on 1st June 1970. So there are few major areas in focus. Anti-competitive agreements under Section 3, which include tie-in arrangements and exclusive supply agreements, exclusive distribution agreement, and refusal to deal. And next major area is to focus abuse of dominant position. This is under Section 4, abuse of dominant position. So, like condition in purchase or sale of goods or services. And next will be like price in purchase or sale of goods or services. So, next will be regulation of combinations under Section 5. The acquisition of one or more enterprises by the one or more persons or more mergers or more amalgamations of enterprise shall be a combination of such enterprises and persons or enterprises. And next, recent developments which we can see in after independence. There are few recent developments since attaining independence in 1947 India. For the better part of half a century, thereafter adopted followed policies comprising unknown as command and control. Next, if we observe The Board of Industrial Finance and Restructuring, formulated under the provisions of SIC Industrial Companies Act 1985, should be abolished. World Trade Organization, which I explained in earlier classes, there should be necessary provision and teeth to examine the upon anti-competition practices that may accompany and follow developments arising out of the implementation of WTO agreements. There are few components of Competition Act. So in Competition Act 2002, there are few components. Let us discuss like anti-competition agreements and also abuse of dominance and the combination regulation and also competition advocacy. These are few components of Competition Act. First one, anti-competition agreements, abuse of dominance, combination regulation, and competition advocacy. Let us move on to Unit 12, intellectual property rights. What are the intellectual property rights? Let me share my screen before entering into the intellectual property rights. As I mentioned on a screen, these are few intellectual property rights. Let us discuss one by one, like copyright, trademarks, patents, designs, confidential information, plant readers' rights, and circuits, layouts, and also passing of geographical indicators. These are few intellectual property rights which we discussed by now. What are the intellectual property rights? First, before entering into our intellectual property rights, let us discuss what exactly is it. IP. It refers to creation of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. These are nothing but intellectual property rights. So meaning of IP, intellectual property rights, is refers to creation of the mind, such as invention, literary and artistic works, designs, symbols, names, images used in commerce. So what is an importance of intellectual property rights? The major importance are like to provide incentive to the individual for new creation. We can create our new creation, like it might be design or it might be image or literary symbols, names or images, and to provide due recognition to the creator and inventor. These intellectual property rights are major important is to provide due recognition to the creator and inventors, and also to ensure managerial reward for intellectual property rights. These are few important things for intellectual property rights. So explore the different types of intellectual property rights in detail in our following things. These are few explored intellectual property rights. First one, like trademarking. So for trademarking, like you can get patent protection for your business and copyright for business for your business and protecting handling your business. And next, what is World Intellectual Property Organization? World Intellectual Property Organization, WIPO. So it is a global form of intellectual property service, policy or information and also cooperation. So it is a self-funding agency of the United Nations with the 189 member states. So their mission is to lead the development of balanced an effective international intellectual property system that enables innovation and creativity for the benefits of all. So let us move on. What are intellectual property laws in India? What is intellectual property law in India? Just now we had seen about World Intellectual Property Organization. Let us move on to intellectual property rights in India. What exactly is it? So there are well-established statutory, administrative, and judicial frameworks for the safeguard of IPR's intellectual property rights in India. But it becomes uh, uh, it becomes mentioned here that India has compiled with its obligations under the Agreement on Trade-related Intellectual Property Rights. Those are like TRIPs. So by enhancing the necessary status and amending the existing status, well-known international trademarks have been afforded protection in India in the past by the Indian Code, despite the fact that these trademarks were not registered in India. So the Trademark Merchandise Mark Act 1958, TM Act 1958, has been replaced by the Trademark Act 1999. So the Copyright Act 1957 has been amended to protect computer programs as literary work. So the Patent Act 1970 has been amended by the Amendment Act of 1999 and 2002 and 2005. So the Designs Act of 1911 has been completely replaced by the Design Act of 2000. These are few trade merchandise. And next, what are the major types of intellectual property rights? So what are the major types of intellectual properties? Are like if we discuss, business owners are granted exclusive rights on the use of their trademarks and geographical indicators which were established by the and next creative artist. So they can also get their copyrights on musical or literary or also dramatic or artistic works for their creation, while innovators are granted protection for their patents, industrial designs, and trade secrets, confidential information, and layout designs of integrated circuits for their innovation. So, functional and ethical inventions. What are the functional and ethical inventions? Let us discuss. So, generally, put an innovation is developing a new idea and putting into it practice. So, developing new idea and putting into practice. So, the term innovation is used here. They refer to the process of bringing valuable new products like goods or services into market. So technological innovation may be classified as several ways like product versus process, radical versus incremental, like basic fundamental versus improvement, and also sequential versus complementary. So there are other things. So while innovations are concerned with the commercialization of new ideas, it constructs and invention may not be directly associated with commercialization. Next, purely artistic works. There are purely artistic works like broad speaking or copyright, protect literary, musical or artistic work like writing and type of publications, painting. Painting, if you take Mona Lisa, like kind of paintings, only if you that one person is having the copyrights on Mona Lisa painting, like melodies or images or films. These were purely artistic works. The protection of informal, like works are protecting soon as it's expressed in a tangible manner, like physically formed or published. And next, protection converts the formulation and expression of the ideas, but not the ideas themselves. Next, let us see what are the symbols, logo, word, design, etc. So, intellectual property rights are like any other property rights which are intangible in nature. So, the intellectual capital has become one of the wealth driver in the present era. So here symbols like if we take Nike, we can see kind of right mark and Apple, iPhone, like we can see half butter Apple. These are kind of logos or designs if we observe. Let's see what are the patents. So a patent is an exclusive right granted for an invention or product or process that provides a new way of doing something. So, new way of doing something that offers a new technical solution to a problem. Next, let us discuss what is a patent, meaning and its coverage. Patent is a monopoly right granted by a national or regional patent office to an inventor who has created something new, useful, and non-obvious. Example like innovation in pharmaceutical sector that results in a new headache pill or a new technology used in a computer hardware. Those were kind of patents. So patent issues also will have during this patent rights. Like what are the patentable issues are subject matters. A patent is a right granted to the owner of an invention that prevents others from making, using, importing or selling the invention without his permission. This is kind of a patentable issue. And one more issue like a patentable invention can also be product or a process that gives a new technical solution to the problem. So it can also be a new method of doing things and composition of a new product or technical improvement on how certain objects work. And next, for an invention to be patentable, it must be safety three criteria. It has three criteria like a new. So the invention should not be publicly known in a way anywhere in a world. And next, inventive step. So the invention must be something that represents an improvement over any existing product or process that is already available. And also, third one, which we need to remember, is industrial applications. So the invention must be useful and have some form of practical application. It should be capable of being made or used in some of the industries. And let us move on to life and duration of patents. What is this life and duration of patents? So section 53 of the Patents Act 1970, it deals with the determination of term of a patent in India. So subsection 1 of section 53 so provides the term of every patent generates after 20th May 2003 and the term of every patent which is not expired and is not ceased to have effect on 20th May 2003. So under this act shall be 20 years from the date of filing the applications for the patents. So those patents for which maintenance fees was not paid within the required time limit and could be restored under section 60 on May 20, 2003. What fees for filing patents. Next, see what fees will take to filing the patents. So there are two elements for cost of getting patents filing in a patent in India. First one, the government fees for forms required and renewals. And next, professional changes for patent professional, patent agent, and attorney. So these are most important. And what is the applicability? Let's see what is the applicability for filing a patent. First, patent filing procedure we need to follow, and patent specifications like a title, detailed description, drawing if necessary, sample or model if required. And next, where the complete patent specifications may contain abstract title, detailed description, drawing where if it is necessary, and sample or model if required by the examiner, and also enablement and best mode, and also claims. So one more or last thing, deposit if in case needed, like microorganisms, for example. These are the few things. And what is, oh, let's see what exactly the title and abstract and detailed description drawing. So I just don't want to get into this detail, but we can. Patent application form. So we have different patent application forms, like Form 1 application for the grant of patent, and Form 2 provisional complete specifications. If we see Form 3 will give us a statement and undertaking by the applicant. And next, Form 5 declaration as inventorship. And next one, Form 26, authorization of patent agent in case filled through the patent agent. These are the things about patent types, and also how can we apply for the patent rights, what is the procedure, and what are the details we need to mention in applying patent rights. Next, let us see what is a trademark. What exactly a trademark? The trademark generally refers to a brand or logo. Anything we can say, brand or logo. So examples like if we see HP, Canon, or Coca-Cola. So these were trademarks, and also Nike, Adidas. So was it indicates the origin of goods as well as indication of quality. These are the trademarks. And what exactly a trademark? It's simple terms. Trademark is a brand or which represent your business. And next, symbols of the trademarks. Like we can use the symbols like TM, SN, and also R should have a circle symbol. TM stands for the trademark and SM stands for the service mark. And the use of TM and SM symbol notifies the public that the company is claiming exclusive ownership of the trademark and can generally be uh, used by one who has filed a trademark application. And symbol R. So it can be used only once the trademark is registered and registration certificate is used. Then we can use R in a circle. We can put a R, capital R. So also you may use the registration symbol only in connection with the goods and services in respect of which the trademark is registered. So this is about trademark. And it also has a registration process like a trademark search, and next step to create a trademark applications, and also trademark registration cost will have a, so government fees like a 4,000, and trademark attorney professional fees is like 3,000 per application per class. So objections depends on cost, drafting, and legal response to objectives can be from 2000 to 5000 in order to overcome the objections. So let us move on duration of trademarks. The duration of trademark registration is like 10 years that may be renewed for the further period of 10 years on payment of prescribed annual fee. We can renew. And the fees is like a trademark application. So statutory fees we have and statutory INR for stamp or individual SME. 9,000 to 4,500. Like we have different types of fees for different trademarks, and applicability will be a trademark or logo copy, like documents you need to produce for that trademark or logo copy, application details like name, address, and nationality for the company, the state of incorporation. And next, goods or services to register and date of use of trademark in India. When in India, when you are going to use the trademark, so that date we need to give and use by you prior to apply. Used by you prior to apply. And next one, service marks. A service mark is nothing but a mark that distinguishes the services of the open form. And also service marks we have, device marks we have, word marks we have, collective marks, and next certification marks, well-known marks, and also unconventional trademarks we have. Those are like color trademarks or sound marks or shape marks or smell marks, and also copyright. So those were kind of trademarks. Let us move on. What are the copyrights? So copyright is a bill of rights given by the law to the creator of literature or dramatic, musical, or artistic works or the procedures of a cinematograph, films, and also sound recognitions. These are kind of copyrights provided under this law. And so it refers to copyright refers to bundle of exclusive rights vested in a owner of copyright by virtue of section 14 of the act. And as per section 17 of the act, the author or creator of the work is the first owner of the copyright. So this is about copyright. And also in Copyright Order 1999 extended copyright protection to work first published outside in India. So India perspectives on copyright protection is like 1957. It provides the copyright protection in India. It confers copyright protection in the following few forms, like economic right of the author and moral rights of the author. And how can we issue covered and not covered by the Copyright Act 1957? So the Copyright Act in 1957 protects original literary, dramatic, musical, and artistic work and cinematographic films and sounds recognition from authorized users. So there is a registration process for a copyright. Here is a chapter 10 of the Indian Copyright Act 1957 and Rule 70 of Copyright Rule 2013 mention the following procedures like application. So under application, we need to add a name, address, nationality of the applicant, nature of applicant, interest of work, and title of work, and name, address, language, some other extra things we need to add. This is nothing but a copyright procedure. And next we need to have a examination. Once the application is filled, diary number is received and there is a provision of mandatory wait period like the 30 days. Next we have registration on further submission of documentation. Next we have a duration. So fair use of documentation or doctrine of the fair dealing will have. This is about copyright. So till now we discussed about copyrights and trademarking. There is also something called trade secrets. So broadly speaking, any confidential business information which provides an enterprise with a competitive edge may be considered a trade secret. So the trade secret encompasses manufacturing or industrial secrets. So a trade secret is information that is important to the business or company and is not known to the public. So it is a term often used to cover information that has commercial value. So how to protect trade secrets? There is a question how to protect our trade secrets. We can protect the trade secret. So by contrary to patents, our trade secrets are protected without registration. That is, trade secrets are protected without any procedural formalities. Consequently, a trade secret can be protected for an unlimited period of time. These are the trademark secrets. So till now we discussed about intellectual property rights, patents, trademarks, and copyrights, and trade secrets. World Intellectual Property Organization before that we discussed. So before winding the class, let us discuss the overview of the class. Today we discussed about uh, here we have a Foreign Exchange Management Act 1999, Unit 10. So the Foreign Exchange Management Act, also called as FERA, which was registered that was passed by the Indian Parliament in 1973. And later we discussed few objectives on for FERA and how FERA converted to FEMA that we discussed, like from FERA to FEMA 1973 to 1990. And later we discussed about differences and also we discussed about Foreign Exchange Management Act 1991 classified and how it's specified, in which areas it is specified, and also FEMA does not apply in Indian citizens, how it did not apply to the Indian citizens, how central government has the authority given by FEMA. This we discussed. And what is FERA and FEMA is providing that we discussed in earlier. And what are the RBI regulations? Here we discussed about RBI regulations, like who is the first governor and first Indian governor of RBI, and how established and what are the functions of Arbitration Act 2002, what is the Competition Act 2002, and kind of regulatory trade practices we discussed. And later we discussed about intellectual property rights. So those intellectual property rights are like what are IP rights and what are the patent rights that we discussed, and what are the trademark, and also what is copyright, and what is a trade secret, and what intellectual property organizations. So for this all intellectual property rights, we discussed what is a procedure for the intellectual property rights, how to register. If we will register, how many steps are there to register in intellectual property rights? I mean, like a trademarking, or else copyrights or anything. And also we discussed about registration process. What is a registration process and what are the things it is contained? How many things are contained in a registration process? and how to protect this intellectual property rights. These are the things we discussed in today's class. Thank you so much. If you have any doubts, please let me know. Thank you.